No, no, my supporting team. Boa noite, então, a todas e todos.
Good evening, everyone who's watching our second webinar
de webinários aqui promovidos
in this webinar series held by the Public Prosecution Office of Federal District in a partnership with UNISUP University and the University of Australia, Embassy of Australia in Brazil. For this second webinar, we will discuss the Brazilian and Australian legal framework for prevention and response to violence, family violence, violence by intimate partners, and femicide. Today, we have a group of speakers, very special speakers. Unfortunately, we will not be able to have Professor Kate Pisquivel. She sent me a message saying that she was sick with no possibility to be with us, but we will have other speakers today that probably will provide us a special evening of discussion and debate. I take the opportunity in this opening to introduce our mediator and next to give her the floor. Today, we'll have the mediation by Dr. Helena Borges Elenek. She is the member of the Australian College of Applied Professions, graduated in psychology, the PUC University of São Paulo with post-graduation in education, psychology, and law school. In 2020, she finished her doctorate with the impact of violence, domestic violence, mental health of immigrant women, and she's also a professor from this institute with psychologists with more than 1 decade of experience with women. Recently, Dr. Anna was invited to be a research fellow, a researcher with University Department of Violence Against Women, a member of the Administration Council of the Unions Committee Association, and awarded in the education in the Australian system. So without further ado, I'd like to give the floor to Dr. Anna Borges, who will mediate the event this evening. Thank you very much. Thank you, Thiago. So today we have a very interesting panel. I will be shifting to Portuguese and English. And unfortunately, as Thiago said, Professor Kate Speaker couldn't be with us today. We hope that she is fine soon. But discussing with Professor Heather Douglas and then later with Thiago and Marcos, I'm going to introduce our panelists. They will have around 20 minutes. Heather will be with us for a little bit longer because she will provide us the contact that Kate would share with us. And the other speakers will have 20 minutes and I will help them to follow the time. And after that, we'll have the opportunity to listen to the speakers discussing among themselves. And then we'll have the opportunity for having some questions from the attendees to the speakers about the reality of Australia and Brazil. So now I'm going to turn to English because I feel a little bit more comfortable because I've been living in Australia for a few years. I just want to remind you.
Thanks, Anna. I'll just share my screen and hopefully this will, okay. Okay, hopefully everybody can see that okay. So I've been asked to focus on the Australian context and prevention of domestic and family violence in Australia. And I think it's interesting to think about this topic because a lot of the things that we've implemented in order to prevent domestic and family violence haven't necessarily been evaluated very clearly at this stage. So I'll talk about what we have done here, but note that I think there's a lot of scope for really exploring how much value these things that have been introduced actually have provided to the sort of aspiration to prevent family violence. So the things I want to focus on are largely to do with legal system because I am very much part of the legal system, but I'm conscious Kate was going to talk about a few things that are sort of to the side of the legal system, and I'll just briefly touch on some of those things as well. But the key things I wanted to talk about was the processes in Australia which have been set up to review domestic and family violence deaths, the introduction of the non-fatal strangulation offence across states in Australia, except actually the state of Victoria where I'm currently living, and also the planned introduction of coercive control offences in some states and the real controversy over the introduction of that type of offence. And finally, some evidence rules that have been introduced that I think are really important for perhaps not directly preventing family violence, but certainly very important in education of the judiciary and the legal people involved in the legal process about what family violence is and what we should be looking out for. So I'll start basically with some of the things that I know Kate was going to try to address this morning before going on to the 4 key things that I really want to explore. And I think it's really important, a couple of key reviews of the legal system and the response to family violence in Australia have happened over the last it's actually getting quite a while now, probably getting up to sort of 8 or 9 years, but there was the Royal Commission into Family Violence in Victoria, which handed down their report in 2016. There was also a very large review of domestic and family violence responses in Queensland called the Not Now, Not Ever report, which handed down its review in 2015. And both of these reviews involved many, many experts giving evidence and lots of survivor stories, putting their information into the process, reviews of data and so on. So, for example, the Royal Commission in Victoria, and I've provided a link there, runs to thousands of pages of recommendations and data and analysis of the way to go forward. And it's really quite an extraordinary document. And it did make 222 recommendations, many of which were ultimately implemented into the Victorian context. And we're still, I think, in Victoria, seeing those recommendations rolled out and assessed and so on, and those recommendations tested as to whether they have been actually rolled out properly and so on. So it's been a really big time, I think, in Victoria. A lot of money has been put towards these processes, and we've seen some, I think, quite significant changes. One of the changes that has been introduced is an information sharing scheme. And I should say a lot of these changes are really challenging in the context of law because it's this real balance often between individual privacy and autonomy of individuals and general views towards protection and safety. And often these kinds of things are held in a very complex balance, I think. And the information sharing schemes are an example of that. So basically in this information sharing scheme context, it's legislative scheme, and essentially in situations which are judged high risk by key partners in the system, so by police, domestic violence services, courts and so on. In situations which are judged as high risk, information can be shared between organisations about the particular couple where there's significant high levels of violence and high levels of perceived danger. And obviously, one of the things we know about our systems, especially in Australia, and perhaps we'll hear more about Brazil, is that we've had this problem with siloing information. So the legal system keeps its information to itself. And not only that, the various parts of the legal system keep their information distinct. Then we have the domestic violence support services keeping their information, health services, police services. So we have all of these different buckets, essentially, of information, which maybe hold slightly different pieces of information in each place. And so we don't have a whole picture of the circumstances for this violent situation for this woman who's in danger. And so the idea of the information scheme is all of this information can be brought together so we develop a better picture and can work out the best way in which to respond to the danger and risks experienced by this particular family, couple, woman, and so on. So that's been introduced, and there's been, I think some success in terms of interventions in that context. So things we can do is obviously we can speed up safe housing. We can ensure conditions on protection orders are appropriate. We can get police intervention earlier where we know there's concerns about breaches of protection orders. We can have child protection oversight and support to the woman with her children and so on. So there's lots of useful things that can happen where we have better information sharing. On the other side of the coin, there has been a concern, and there's been a review of the scheme, and generally it's positive, but there has been a concern that when women know that their information might be shared, they might be reluctant to actually seek support. So that, I think, is always the concern about these essential interventions into the privacy of people. But certainly that's something that's been introduced in Victoria and has actually been brought into play in other states in Australia as well. Most other states, in fact, have copied this scheme now. We've also had revision of risk assessment and management of risk assessment tools, and obviously this is really important, and this relates to something I'll talk about in a moment around the death reviews. But certainly the risk assessment process is something that is constantly in flux and developing as we gain more information. So this is another problem that we've had in the past, is that a lot of services have different risk assessment tools. And there is still, I think, some differences between risk assessment tools. But the idea is to bring those into alignment so that we're working across system with the same system of risk assessment. So we're all on the same page about how we're understanding risk. So that's been an important discussion in Victoria as well. We're not really there in some ways. We have a risk assessment tool which is supposed to be consistently used, but obviously different people use discretion differently. And so we're still working on developing and supporting and training around those risk assessment tools. There's also been a strong focus on what we've sort of thought about as keeping the perpetrator in view. I think there's a view that for a really long time we've really been very victim focused. What can we do with the victim? What can we do to get the victim into safe housing, to get her away from the perpetrator, to get her somewhere else? And obviously that's incredibly disruptive for that woman and in a sense puts the pressure on her. We've asked her to disconnect from her technology because it's dangerous. We've asked her to move her kids to a different school. We've asked her to do all of these things. And really that's taken the sights off the perpetrator. So there's a real sense that we have to put more onto the perpetrator to change their behaviour. So that has led to the development of a lot of perpetrator interventions in Victoria and experiments with various forms of perpetrator intervention, and that's also an ongoing process. We still don't have enough perpetrator programs to service the referrals, both mandatory from courts and also requested referrals from individuals who are seeking support for change. But that's certainly something that we're working on strongly as a result of the Commission as well. There's also been an implementation monitor introduced, and I've connected you to a link there if you're interested in exploring this more. But essentially, obviously, with the problem of introducing a whole lot of recommendations and actually the government accepting that those recommendations should be rolled out, is how do we keep a check and balance on whether they are being rolled out and whether they're being rolled out properly. And so the implementation monitor keeps an eye on those recommendations and hopefully is a check and balance and an annual report of how the recommendations are going with the rollout. There's also been a lot of money put into research. So research to determine how things are going. And there's a current round, for example, from Family Safety Victoria, which is the organisation set up also to assist with the rollout of these recommendations. And they provide various grant rounds for researchers to explore how these recommendations are rolling out, whether people are understanding things, what could be improved, and so on. So there's a real focus on this being a fairly dynamic scene with ideally proper resources applied towards ensuring those recommendations are implemented and implemented successfully. So I think that's a real snapshot of the things that Kate was going to talk about. And I'll try and answer questions about those things if possible, but I'd like to move more now to the things that I was hoping to focus on in my presentation. So some of the things I wanted to focus on to start with were domestic violence death reviews. For me, this is one of the most important things that have really been in the spotlight, I think, in Australia over the last kind of probably 10 years or so as we roll out developing death review processes across Australia. I should say that there isn't a consistent approach to domestic violence death reviews in Australia, and we have a range of organisations that do this slightly differently, but all of those organisations are linked up. So many of us will be familiar with coronial inquests where there's a death which takes place and it's not completely clear how or why the death occurred, and there might be a coronial inquest in the courts as to what went wrong with systems and how we could do better to avoid this death in future. So we do have that inquest process in Australia, and that happens in every state and territory. And I should say that Australia is a federation of states, so things that happen in one state don't necessarily get followed in another state. So although we only have 25 million people or so, we have 6 different states and territories, and so 6 different states and some territories as well. So we have a numerous various 9 jurisdictions altogether, including our Commonwealth federal jurisdiction. So, you know, things are more difficult in that sense to connect up. But the death reviews is an example where we have connected up well, and each state and territory share their information around their reviews of domestic violence deaths. So I think that's what's really important around death review systems, is we don't look at the single individual death or inquest, which an inquest does. Obviously extraordinarily important during an inquest, but also really important to be able to compare those deaths in the domestic violence context so we can see what the themes and patterns are and where things are going wrong, both in each state and across the country. So I think that's what's really important about the death review process as distinct from the inquest process, although both are obviously really feed into each other and are really important. So, for example, ANROS, which some of you will be aware of, but it's a very large Australian research organisation focused on Australian domestic and family violence research, and they have supported these death review organisations across Australia to come together to share their data in a report in 2018, which reviewed 240 deaths. And they found across these reviews across the country that the majority of offenders had problematic drug and alcohol use in the weeks leading up to the death. 1/3 of employers, people who killed, were actually employed. So it's not all about people who are unemployed and people who are experiencing poverty. Not surprisingly, this review of deaths across Australia found that separation or intent to separate was a flashpoint in most cases. And also there was a common history of non-physical abuse and controlling tactics used. So I think there are some important sort of myths that can be dealt with in these reviews. So, for example, this notion that offenders who kill in this context or domestic violence happens where people are poor. This was a situation where 1/3 of offenders were actually employed. And also this notion that there's necessarily physical abuse leading up to a domestic violence death. This kind of review of deaths showed that coercive control was also really important in the background of many of these deaths as well. really important to be able to look at these patterns across the country. More information from this particular report from AMROS. We know that this is a situation which is mostly a case where men kill women partners, but still there was a good proportion of women who killed their male partner as well in response to domestic and family violence. But mostly it was primarily male offenders who were primarily IPV abusers. Very few women who killed were considered to be primary IPV abusers, which was perhaps not surprising either. Also interesting here, and a concern, I suspect, we have a situation in Australia where people can take out a civil protection order. So the court can provide a person who's experiencing domestic violence with a protection order. This is a civil order which places conditions on the perpetrator to stay away, not be drinking when they see the victim. The concept of the conditions is as wide as one can imagine they might be, that a court can make. And you can see here that nearly 90% of women in these cases actually had a protection order. So although there can be a criminal prosecution if conditions for protection orders are breached, so there can be some teeth behind protection orders, I think this suggests that, protection orders are not particularly protective, essentially. So it's a real concern as to how we might strengthen protection orders or make them more useful, given that, they were present in many of these cases where women were killed. As I said just before, separation is a flashpoint, and I think we are very clear about that, but it doesn't hurt to keep talking about this. In 130 cases, women had said they were separated or going to separate. So this notion, why don't women leave? Often they don't leave because they know if they do leave, they're in serious and very serious danger if they do leave. So that's why women don't leave. So I think, as much as anything, these, of course, the idea of these death reviews would be to make recommendations for change. So, for example, change around protection orders, change around drug and alcohol intervention, for example. As much as it might be to make recommendations, it is also helpful to constantly be, I suppose, myth busting around domestic and family violence and getting rid of those assumptions that are really hard to remove from people's minds. Why doesn't she leave? Well, because it's dangerous to leave. So this really shows that up. But I think that the death reviews and the inquests around deaths in family violence are incredibly important. And I often am involved in the inquest process, which calls on experts and also hears from the people involved in that woman's trajectory before her death to see how systems could have been dealing with things differently. I think they're really important, and they've been much better resourced in recent years in Australia. There are other matters that we've introduced, and these are my questions really about the role of criminalisation and how useful and helpful that is in prevention. I think we make an assumption that it is useful in prevention, and there are good questions, I think, for us to explore much more over the coming years around the role of criminal law in these areas. In Australia, we have criminalised non-fatal strangulation, and obviously many of you will be very aware of the dangers and risks associated with non-fatal strangulation. So non-fatal strangulation is dangerous in and of itself. It doesn't take much to kill a person by strangling them, less than a few minutes of holding on the neck, and it takes seconds really to cause significant brain injury. There are other injuries that come with strangulation, including, miscarriage as a result of strangulation. So there are very serious injuries associated with non-fatal strangulation. But also it's a serious risk factor for future serious violence and death. So women who are strangled by their intimate partner are 7 times more likely to be killed or experience serious injury from that partner in the weeks following the strangulation event. So it's a big deal being strangled. It's obviously a real statement of control. So it's very much associated with domestic and family violence context and the notion of coercive control. So obviously there's nothing like holding a woman around the neck, essentially saying your life is in my hands. I mean, what better way to control someone? So non-fatal strangulation is a really key issue in the domestic violence space, and many women experience it in their domestic and family violence relationships. So there was a view that we should criminalise this offence. There were some reasons behind this. One, to recognise the harm of it. Two, to make sure it's listed on people's criminal records so that we know there's a history here, and if this person comes back before the police, we see this on their history and it's a red flag for future risk. And also it's the educative function of criminal law. Some of the controversy around its introduction was this idea, well, we already have assault, we already have attempted murder. Isn't this just repeating what we already have in our criminal laws? And the view ultimately was no, this is an important discrete offence. So we have rolled these offences out, and I don't expect you to read this, and I can share these with you later if that's of interest to people. We have rolled these offences out in every state and territory in Australia, except the state I live in, which is Victoria. And our resistance in Victoria is that we already have assault and attempted murder. We don't need it. So, I'm working on that because I do think this particular offence is useful and important and doesn't widen the net of criminalisation, which other offences might. It simply properly names the offence we're interested in here, in my view. Some of the questions I have around the way we've introduced strangulation, though, in some states, is this notion of consent. And if we agree that non-fatal strangulation is an incredibly dangerous event, is it appropriate to say that people can consent to it? Now, this is tricky because I know that, in this era of, autoerotica and people saying that they're using strangulation in their sexual lives, this is something that might be controversial, but I question whether we should be saying that you can consent to an incident of strangulation, especially when we're saying there's a history of domestic and family violence. So in a number of jurisdictions, this matter can only be charged in the context of domestic and family violence. So really, whether we can say that there's a consent here really is quite problematic, I think. There are also issues about exactly what the strangulation is. And there was some debate, for example, when the Queensland law was introduced as to what strangulation means. And does it mean stopping the breath or does it mean hindering the breath? And the law now has settled on hindering the breath. So I think this is a really important offence. I think broadly in the community, it's certainly been educative. And I think it's been important in fixing criminal records so that we know what this history of violence is that this person has played out. A big controversy in Australia at the moment is this offence of coercive control, and many, certainly my work on coercive control has been very focused on Evan Stark's famous book, I think. And he talks about coercive control, recognising that domestic and family violence perpetrators use various means to hurt, humiliate, intimidate, exploit, isolate and dominate their victims over time. He says if abusive relationships were filmed in slow motion, they would resemble a grotesque dance whereby victims create moments of autonomy and perpetrators search and destroy them. So in Australia, we have talked about criminalising coercive control. This would be a net widening offence. And by that I mean this would really criminalise behaviours potentially that are not currently criminal. So that's, I think, the big difference between this and non-fatal strangulation. So why would we criminalise coercive control? I think some of the reasons why we would criminalise coercive control is because a lot of women who report domestic and family violence report that the coercive control is the worst aspect of their experience of violence. The constant put downs, the demeaning behaviours perpetrated against the woman, these are things that really destroy her sense of freedom in the world, her sense of being able to interact confidently in the world. So they essentially destroy her. So this is why we would think about criminalising this type of behaviour, because it is terribly harmful. So things like a woman who says that she is forced to eat chilies, that she's forced to shower outside under the cold hose during winter, that she is forced, that the children are forced to call her particularly rude names. These are things that are not criminal at the moment, but potentially if there was a pattern of this kind of behaviour, this could be a criminal offence. And obviously that is terribly demeaning and destructive to that woman's sense of autonomy and freedom in the world. So that is why we would criminalise this particular offence. So it would be that it would highlight this as a harm. It would recognise victims' harm. It would also have the educative effect that we unfortunately know. Often we need criminal law to really get the message out there that this is harmful and wrong. And it reflects what we say is wrong. The criminal law is a statement of what we think is wrong in our community, so it would do all of those things. In Australia, though, we've had a very strong debate about whether this is too much of a net widening offence, if it's too complex for us to really criminalise. We have a situation in Australia where we have around, although Aboriginal people make up about 3% of our population, Aboriginal and Torres Strait Islander people, the original inhabitants of Australia, make up only 3% of Australia. They make up around 20% of the prison population. And, you know, police contact with Aboriginal people is hyper, basically. So it is a problem that if we introduce an offence in Australia, we know that it is disproportionately going to be Aboriginal people that are charged with this offence. And other groups, such as migrant groups, are also disproportionately charged under these kinds of new offences. So this would be a problem. So there's been a real concern about that. There's also been a concern really about, well, what does it look like? Normally we can say with criminal law, the behaviour looks the same for each individual. So if someone is hit with a fist, that looks the same for every individual. But coercive control, the beauty of coercive control from a perpetrator's perspective is that it morphs and changes in line with what is needed to control that particular woman. That's really difficult for criminal law to capture. And so there's been real concerns about whether we can properly capture this within criminal law. Obviously, this has been done. It's been done in the UK, Scotland, Wales, England, Ireland, and there is arguably some success with that process in those countries. We have promised to introduce coercive control offences in Queensland now and in New South Wales, so those will come in those states, but other states are yet to commit to introducing this offence. There is an offence of emotional abuse and financial abuse that's been introduced and present in Australia in one state for quite some time, but that has not been regularly charged. So this is a bit of watch and wait, and perhaps we can talk about this a little bit more in the discussion. And finally, I wanted to talk about these evidence provisions in our Crimes Act and Evidence Act in Victoria and Western Australia. These are also going to be introduced in the coming months and year in Queensland. I won't show you these, they're quite long and complicated, but I think they're really fantastic because these evidence provisions were actually introduced into the evidence legislation in Victoria back in 2006, quite some time ago. And they were essentially introduced to ensure that evidence about family violence could be introduced in cases where women are killed in response to domestic and family violence. So we have a problem in Australia that self-defence really is only a defence in situations where imminent serious harm or death was felt or feared by the perpetrator of the death. So the problem with domestic violence is a woman could have experienced domestic and family violence for a number of years. She knows that it's escalating and she is very fearful of death or serious violence. And the thing that is the last thing she experiences before she kills her partner is that he comes home drunk, and she knows that what happens next is she gets a very serious beating, and those serious beatings have been exacerbating and heightening over the last few weeks, and she grabs a kitchen knife and she kills him. Now, that is not imminent harm in the historic way we think of imminent harm, but if we think about it through the lens of domestic and family violence, we can show that the woman believed on reasonable grounds that it was necessary for her to defend herself in this way. So these provisions, these evidence provisions were introduced to allow evidence of domestic violence to be brought into the court, to show that history of domestic and family violence, to explain her situation of why she believed imminent harm or why she believed responding in this way was necessary. So in that sense, it avoids the prosecution of women for murder in situations, and they can now use self-defense or duress in these situations. But I think the preventive aspect of this is that it's had a much broader effect, an educative effect on lawyers. Lawyers have to use this provision, not just in murder cases anymore, but across all provisions where people are charged with domestic and family violence. So it's meant that domestic and family violence is much more commonly introduced into our criminal courts. So people are thinking about it, they're using this information and they're understanding it. And it's a broad provision which includes coercive control. It includes things about understanding separation and the dynamics of domestic and family violence. It includes information about the cultural background and how we might see domestic and family violence differently because of someone's cultural background. So they're really helpful in terms of exploring, allowing the court to explore domestic violence more broadly. And through that, I think we're educating a whole new generation of people involved with criminal justice about what domestic and family violence looks like in this much broader way. So I think they're really important. And that basically is where I want to end. I can share these links with you, and hopefully they will be of interest if you're interested in following up. I'm afraid they're all in English, but happy to answer questions as we go through today. So thank you. Okay.
Thank you, Anna. I'm going to continue in Portuguese from now. First, I'd like to thank for the invitation. I am quite happy for being here today with you in this panel and exchanging ideas with our colleagues from Australia. So for me, it's a great honor because I believe both countries, both powers of the global South, they have a lot to exchange in experience, especially on this topic. So I'm going to share my screen now. Please let me know if you can see my screen. Okay, thank you. So I'll start my presentation first, sharing a little bit of my history in order to inspire some other students and researchers to follow the same path that we are doing, as Thiago and Anna is doing as well, is that establishing a studying partnership with Australia. So I have here the picture of my sandwich doctorate supervisor, Professor Angela Tafte from the Latrobe University, where I had a part of my doctorate on collective health under her supervision, and studied especially during this this moment that we tried to understand at the time what were the public policies of Australia towards domestic violence against women. And right after, we managed to have Professor Angela here in Brazil. She came as a visiting professor. And next, I returned there with my postdoctorate and then as a visiting fellow researcher in the Center of Research Excellence in Safer Families, University of Melbourne, with Professor Kelsey Haggard. So everything that I am today is thanks to what these two professors guided me, and they are still guiding me. So over this past 12 years of partnership, I have here some publications. I can share these slides later. So who have interested to know a little bit more. And my history for the place where I'm speaking is from the health position, health standpoint. So my postdoctorate was in public health. Today I work in the collective health department, and I'm going to try to talk a little bit about Brazil, but with some topics regarding the health sector. So I'm happy to be here with you with the law sector because I always learn a lot with law people. So in order to understand the Brazil context, especially for our colleagues from Australia, we need to get back a little bit on our history. There is a colonization history as Australia as well, and we have the genocide of our original people, the indigenous people. If in Australia is around 3%, the professor had said, of indigenous people, here in Brazil, it's around 0.5% of our population that are self-dominated indigenous people. So it was a huge genocide. And we have a past of slavery and which the racism impact we can see till today, differently from Australia with a more later democracy. In Brazil, we recently left a dictatorship. It was marked from different events of torture, violence. I mean, there is this penalization of violence of our history. And in addition to that, Brazil, as a Latin country, has this sexist culture that is like more present than countries colonized by the British as Australia, New Zealand, and Canada. So the World Health Organization estimates in Brazil 1 in 3 women or either suffered or are suffering or will suffer the violence that's the so-called intimate partner violence. And if we consider our homicide level, if we consider the absolute number in Brazil, Brazil is the country with the highest number of homicides of the world. But our population is huge. So when we get to rates, we are among the 10 countries in the world of homicide and femicide. And it's important to understand that considering the epidemiological data, we follow these numbers, this index, and over the past years, we can see in the chart, the number of homicide against Brazilian white women is decreasing, but the other side of the coin, that the homicide level against Black women is increasing. It highlights the inequalities growth that we have in Brazil. And of course, the country is not investing in public policies on an intersectoral network to protect and prevent violence. So I'm going to talk about the research scenario with our work, that is with the Brazilian women houses, or Casa da Mulher Brasileira in Curitiba. So here we have the map of Brazil, we have the state of Paraná, and I'd like to thank the director of the Casa da Mulher, that is Mr. Sandra Prado, where we work since 2018, a research project on participative action research. So it's a research with the working women and the women served in the house. So I have this picture of Sandra because she's important in this work. She's the director. And on behalf, I'd like to thank the house and the employees, all the team engaging in this research. So this Casa da Mulher Brasileira, Brazilian Women Houses, is a public institution established in 2015 or 2016. The past administration was more progressive, and it was supposedly to have an institution such as this one in each capital of Brazil. But we only have 7, and we are not kind of standing by. We are waiting the inauguration of more houses in other capitals. I remind you that we have 26 states plus the federal district. So we have to have 27 houses like this. Just to give an idea of the importance of this space, from 2016 to 2020, we assisted 250,000 people, around 50,000 people. And within this project, we have this work where we estimated the number of people and profile of the users of this service. So I have a short video just to show, because I do not work in the house. So the video maybe can share a little bit more of how it works. And we have English subtitle, right? So, in summary, Casa da Mulher offers, since the psychosocial support, that it was a demand from the women that went to the specialized police department, and often they needed people to listen to them, their cases, with a psychosocial approach that with more humanized. And there is the Mariada Penal Law Patrol, that is a branch of the municipal guard to assure that the protective measure is fulfilled. And we have also a court for domestic violence against women, the Public Prosecution Office, the Public Defender's Office for women that can't afford a lawyer. So free service offered as all the services offered by the house. There's a temporary housing for those with a greater risks for children or their pets, and the playground for children, and the financial autonomy and transportation center to transport these women for any other services necessary. And there at Casa da Mulher, we developed some researches within this huge project, and one of them we have been translating in the transcultural adaptation of questionnaires instruments on violence for the intimate partner. And one of them was the Composite abuse scale. That is a scale developed by Professor Coercive Control. And why it is important to establish a scale? Because in health services, when we ask if the woman is under violence, she answers no. But for the professional worker, it's important to identify that in order to provide assistance. So when you have indirect questions, for instance, have him ever called you as crazy woman, or tried to pull you, or tried to have sex relationship against your will, forced? So when we have these sort of questions, this questionnaire, the woman feels, how can I say, she can visualize that and answer that directly. So it is different than you have a question specific on violence. And this translation and cultural adaptation process, we always follow a protocol. We translate it here, we publish, and it involves the translation by independent translators, the cross-cultural adaptation and the analysis by the developer, that was Professor Kelsey. The translated version is reviewed by experts, committed professors with doctorates on the field. And then we have cognitive interviews with women assisted by the house to see if they understand the questions. And finally, we have the conciliation steps. We have been applying this scale, this form, with women assisted by Casa da Mulher, and it's helping, including the professionals in the psychosocial department, to understand the severity of the case. Because in the end, we have a score. So I don't know if you can see in the screen, but when there is never, so if throw me or put me. So if she answers no, it's 0. If it's one time, it's 1 point. It's many times 2, and daily 5. So we have a score of up to 150 points. So we can measure the abuse level that the woman's undergoing. And this scale is focused on topics regarding psychological violence, emotional abuse, harassment. There are other dimensions beyond the physical violence. Another scale that we developed and we translated is the danger assessment scale. It is an instrument developed by Professor Jacqueline Capable from the US, and it assesses the femicide risk. So both scales were already translated for more than 10 languages, each of them. So these are instruments applied in a significant sample of women in the countries where it was developed. And we are translating these for Brazilian Portuguese with a partnership with Professor Devlin Evans from Emory University in the US. So we developed a pilot step. She created this step in the US of translation, and we have a pilot here to test with the women assisted by the Casa da Mulher.
When the Brazilian women respond to this questionnaire, well, both of them, they see many situations of violence that would go unnoticed. So for instance, in this case right here, when you ask, does he have a gun? And they say yes. So it's another point in the scale. This one has 20 points. So for each yes, it is one more point. So at the end, she generates this number that it is, of course, it's research material, but for her, it's like a warning sign, as in you are in a high level of even suffering femicide. So we are working in this translation process. So what we're doing under the supervision of Professor Kelsey Eggert, that developed that in Australia, an app, a platform to support women under violence to execute a safety plan or security plan. So what is the idea of the app? Why I decided from Australia, my plan in the United States, I can from Australia, and you have the New Zealand one. And they answer this questionnaire and they receive on screen what level they are of abuse, violence, or risk of femicide. And from that result screen, the app allows the woman to navigate in different screens and create a safety plan. For instance, if she has children, to try and set up a plan to keep the kids safe. And if they want to get out of the relationship, what are the steps that they must follow to be away from this relationship in a safe way? Because as Professor Heather has mentioned, many of the homicides happen when they decide they want to separate. So the idea is this app that has been tested in the different countries. So the idea to bring this to Brazil and for the women to be able to lay hand at that resource. So this is done with Emory University, and we have a preliminary version that I'll show you really quick. It's not available for download yet because it's still being developed, but the woman answers the questionnaire and then they have a feedback of her violence level, and they can navigate to get to know types of violence, laws, and to see the Curitiba network, and to design the safety plan. And just for you to have an idea, we had put up a map of all support services that include health, public security, the social assistance network, and of course, a quick button, a quick exit button, should the harasser sees that she's using that. So it sends to a random Google page, okay? So beside this project that we're developing at Women's House, well, we are also developing one with a unified health system, and to try and use the potentiality that our unified health system, which is universal, public, free, accessible, that it has for the action together with the cases of domestic violence. So the Brazilian Health Service is called SUS, Unified Health System. It's an acronym, and it's decentralized. So each neighborhood in each city, they have their basic health unit, and they have a team that we called the primary care team, composed by the family health team. And those teams, they have a strong bonds with the community. So they visit their households, they go into people's homes, and they identify domestic violence cases. So they have a great potential to intervene. But those interventions, from my thesis, my doctorate thesis have been studied. So those are not, there's no protocol for these interventions, like for the whole country or for states. So the interventions are very much based on each team. Let's say if a team wants to act, and a question that we ask is how to make use of this potential that exists to try and prevent domestic violence. The World Health Organization has a curriculum to train healthcare professionals to take care of people under violence, and we are adapting this curriculum for the unified health system. This project will have the funding by the state of by the state of Victoria. So basically, we're putting together the professionals, the unified health system in the municipality of Paranaguá, and professionals in the Brazilian Women's Home, and researchers from our country as well as from Australia to try and design an adaptable model for training in domestic violence. We saw, well, the idea is to see what there is in this curriculum and to see what is there at the edge. So the contents go from gender, on how to approach, how to elaborate the plan, and what is the role of this intersectorial network, and mental health as well. So the format would be in person with different meetings with role play. Not only theory, and with the resources, the professionals also point out that the idea is to have a more private spot in the unit for this service to take place, and each service, each unit to have a reference professional that we call the champion leaders. So very briefly, that's what I wanted to bring to talk about the unified health system in Brazil and the research that we have been developing, which come from this partnership that we have together with our researcher friends. So thank you very much for the opportunity. Once again, thank you.
Thank you, Marcus, very much for your presentation. And it's always good to hear someone talking about SUS in any context. I think we get to talk more about it later. I want to apologize. I didn't realize that when I speak English, I had to be in the English channel. So some of the listeners did not hear some things that I said, and I didn't realize. I just assumed we could move between languages with no technological glitches. We will move now to our last presenter for today, Dr. Thiago Pierogiavilla. And thank you, Thiago. Thiago is an associate professor of the Doctor of Law program of UniCeuB, an affiliated researcher at the Gender and Family Violence Prevention Center at Monash University, and at the Institute of Criminal Law and Criminal Science at the University of Lisbon. He holds a doctorate in criminal sciences from the University of Lisbon and is a postdoctoral research fellow from the School of Social Sciences of Monash University, Australia. He's a senior prosecutor in Brazil. He has been a member of several Brazilian national boards and has extensively researched in the areas of violence against women, racism, police accountability, and criminal procedure. Thank you, Thiago.
Good evening to all of you. Thank you, Anna, for presentation. I'd like to greet Heather and Marcus, our colleagues that are sharing the panel with us, and everybody who's watching at home, and the ones who are going to watch in the future when it goes on YouTube. I have prepared a couple of slides that I'd like to share them with you. There you go. So my idea tonight, let me start my time here. Well, the idea is to talk about this theme, about the Brazilian and Australian frameworks for the prevention and response to family violence, especially femicide. Anna was kind enough to introduce me, so if you're watching us at home, just like to show these two links. Is the academia.edu. Everything that I do, I publish there. And the other one is my Instagram with the events and lectures that I'm always talking about that there. So briefly, what would be the main normative references in these public policies to prevent violence against women in the Brazilian context? Then to advance in a couple of themes that I want to go deeper in the discussion. Well, first, we have in the Brazilian context 2 international treaties with an important influence in this wider structure of the legal system that tackles violence against women. The Convention of Berlin of the Inter-American system of the OAS, It was created by Brazilian politicians in 1996, and then the Framework Convention of the United Nations that will only incorporate into your legal framework afterwards. And then the important normative framework that we have is the Mariada Penal Law from 2006. And it's always important to highlight this is a law that came from the activism of the feminist movement. It was not us in the justice system that fought for the enactment of this law. And there's history that shows how much the legal operators were against this Mariada Penal law. So this is a law, and it's important to say it's specific to tackle domestic violence, but it has an initial phase, which is a set of guidelines that is quite generic. That at the end of the day, they are guidelines of prevention, policies for the prevention of violences, because I can't work preventively in domestic violence without tackling the root of the problem, which is gender inequality and the inequality of power, men versus men and women, and social assistance, and public security, but in the justice system as well. And then we have a second cornerstone framework, which was the criminalization of femicide. Here in Brazil, it happened in 2015. In Brazil, we were one of the last countries in Latin America to criminalize femicide. And this was interesting. That is typically Latin American movement. We have the criminalization of femicide in all countries of Latin America. There are some 18 countries, and more recently, I have published an article in the Current Sociology together with Vania, analyzing the compared law in the different countries. Our action follows a precedent of the Inter-American Court of Human Rights of 2009, when it judged the case of Ciudad Juarez in Mexico. The cotton field cases that many women were murdered in the city that is in the border between Mexico and the United States, and it followed the deficiency of the state to clarify these deaths and the idea of this criminalization, that naming the right, not only in sociology but in law, giving a name to this phenomenon, I can induce a better awareness or recognition of these women in the legal system. I will induce a better social awareness on the existence of deaths of women by the very fact they're women, so derived from the spousal relationships. I will produce better statistics on these deaths, and I will learn more to prevent others. And also in stating prevention policies. And then Mariada Penal Law and the Femicide Law were invested in guidelines of action. So I'd highlight three important ones. And for 2016, you have the National Guidelines of Criminal Investigation, Gender, Composite, SENASP, and Ministry of Health, and the Secretariat of Policies for Women in 2016. And last year, we had the issuing of the National Protocol of Judgment by gender perspective by the CNJ, the National Council of Justice. We had three national plans for policies for women: 2014, 2004, 2007, 2012. So the last plan was already in 2016, and ever since we haven't had a national plan for policies for women. But I like to use the last one as a paradigm. We had some laws that talk about that talk with their theme, with like a reform in the sex crimes and women in criminality. And last year we had a boom of legislations in this violence against women. We had four very important laws that were enacted. I was limited to these four, but we had the criminalization of stalking, Brazil, and right after psychological violence, uh, which is close to what Professor Heather has mentioned in Australia, the coercive control crime. I believe they are very close, and then the same challenges Professor Heather has brought, we are facing in the national context. And if on one hand, apparently it's positive to criminalize that, because this shows this sends a message that that's something serious and something that we need to be attentive to, especially the justice system operators. They cannot neglect that. It is so severe that is a crime, but it is also hard by the very operators in the justice system to recognize a violence that by definition is invisible. A violence that I need an expert in psychology to just to let me see the existence of this violence. And this creates a paradox. Either I'll ask the police officers to learn psychology, or I have to have psychologists to the police stations to let them see. And if none of that happens, what will happen ultimately is that the women, they go to the police departments, they will tell episodes of violence that will not be read as violence. And then I will continue leaving this form of violence invisible, which may be just a shot in the foot, because instead of bringing visibility, I will bring more invisibility, and I'll bring more frustration of expectations by these women. So there is a potential, but there is a risk, and we are aware of that risk. In the beginning of this year, I created a criminal investigation script for psychological violence and stalking that was sent to several police departments and different systems, different prosecutors areas, and they're using as a starting point for each place to develop their model of investigation. Fact is that we need to bring two knowledges together that were not in sync for us to try and see this violence. Because as Marco said, if I only ask her, did he practice psychological violence? She's going to say, well, no, there were no violence. But if I ask her, did he forbid you to leave the house or to visit your friends or to work? Have you ever had unconsented sexual relations? Would he always talk you down? She'll probably say yes. And that's when she sees a new form of violence. There was an important law also last year that was named Mariana Ferrer Law. It's a law from a specific case of a Brazilian influencer. There was a victim of rape, and in the hearing, she was accused of not being a legitimate victim by the justice system, and it was during the pandemic. This was recorded, and then it was shown around, and it generated a general commotion. So they created a specific law to prevent the re-victimization of women in the hearings by the members of the justice system. And the last cornerstone was December 20th last year. At the end of the year, they issued a national plan to tackle the femicide. The current administration added to that, and it was highly criticized by the feminist movement. It was criticized by the fact that it was built without a prior dialogue with women, and criticism in shrinking the object of a national plan. But all policies for women, it would be just femicide. But it's not enough not only to kill, they need to have quality of life. And two important criticisms is a plan that it doesn't show the gender perspective. There's a restriction. The current administration doesn't like to use this term, and it doesn't have a race perspective. So there's no gender and race. Those are the main criticism that have been brought. So with this presentation of the scope, I'd like to advance in these two themes with you.
One of them, they are talking with researchers that we have. I have only 9 minutes left. So two research that I developed here that I believe that talks with what Heather said and Marcus as well. One is one of the research that we had on femicides in Federal District, Brazil. And I think that's interesting because its methodology can talk and interact with one of the follow-ups of the National Plan Against Femicide, that is the creation of state observatory to tackle femicide. Each state shall create an observatory. Actually, the plan says to create some observatories as pilot projects. And I believe that it interacts with what Professor Heather said, that one of the great advances in the Australian system was after the creation of these domestic violence death reviews. I mean, institutions that have specific assignments to research deeply in a qualitative manner why these people died in domestic violence context, and what can we learn from these deaths in order to improve public policies to prevent these deaths. And a second point, that is a very recent research that we are releasing this week, an analysis on how the legal system has been decided on the urgent protective measures in the context of the federal district. And I believe that this is a research that has some interesting topics to enable us to reflect on what should be a observatory to Mariada Penal Law's application, because they are two monitoring instruments on the implementation of these public policies guidelines that are in baby steps in the national context that need to advance better. So first, in this research on femicide, a research developed by the Superior School of the Public Prosecution Office, with the support of the Prosecution Office, and also on the Violence Control Program on Health, and also Instituto Anis. And what we have this research, we have the 2 years in Federal District, 2016, 2017, 100 of femicide cases over this period. Initially, it was 44 cases, and then we reduced to 34. We excluded those ones that the police were not capable to clarify the perpetratorship or out of domestic violence context. In addition to legal procedures of femicides, we analyzed the previous procedures, the health registrations, and also interviews with the victim's family and relatives with the approval of the Ethics Council. And we tried to analyze, similar with the death review panels in other countries, why do these deaths happen? What is the context? What can I learn from the death of these women to avoid other deaths? What the public services could and should have done in this case to avoid the death of these women? And case by case, we always analyze all the public policies range, the primary prevention policy, the secondary policy prevention, and tertiary prevention policy. And in this tripartite of public policies, I had in a book of mine with Gianna Pazan and Bruno Machado that analyzed the prevention public policies in the Brazilian context, and the opportunity that was in 2019, analyzing the main researches that we had in Brazil with this focus: primary prevention, education, social awareness, the health, primary health care, secondary prevention, or with risk groups, most of the health interventions we have here, social assistance, and tertiary prevention, police and justice. And the findings that we have, the femicide profiles, and what is the interaction with the prevention policies. So first, 100% of the cases of femicides take place with sexist representations. It's a man that doesn't accept the end of the relationship, a man that has his authority questioned as the head of the house, or a former partner that wants to keep his authority, and in a conflict event goes there and harm the partner. And it gives an indication clear that we need to advance on primary policies to deconstruct these social roles in schools, universities, social campaigns, the intersection of women in power positions in the society. Another important finding in the research: in every femicide cases, there was a historic of prior violences to death, 100% of the cases. At least, and we have a psychological violence, but only in 23% of the cases, the women had into the police department and registered the case. So in the case, in 100% of the case, the woman was under violence and didn't communicate the police or the authority in 72% of the case, and then she was killed. So it's important to give visibility to all sorts of violence, especially psychological violence. And on the other side, open the door, other doors to the women, in addition to police station, because the woman maybe is not willing to go to the police station, but maybe she goes to another service. And 50% of the cases, relatives and friends were witnessing the violent situation. So maybe it's important to think an intervention, raise awareness with campaigns with people close to women to provide assistance to women in violence context and in severe situations to denounce, specifically directed to the police, these violence. And this is important finding. 70% of femicide victims in Federal District was migrant women. And this is an information that we didn't have clearly. But with the research, it was very clear. In the Federal District, only 33% of our population are of migrant people. Federal District, it's common. Brazilian was founded in 1960. During the 90s, there was a very encouraging idea for internal migration, especially from northeast of the country. And these people that displaced internally, they came here with no bindings, with no linkage, so they are under risk of violence, and this is clear in the research. Most of the victims had a poor education levels and the social inclusion, the withdrawal, the displacement of these people from misery in places around our city is very important. 71% of the victims, 62% of the perpetrators were Black. So gender and race intersection is very important here. And 47% of victims had violence registered in their health history, but only 19% had mandatory notification by the health system. So clearly it's a failure in the health system that identifies the violence situation, but it doesn't refer the women within the health system to protective systems. Also, the risk factors analysis in these violence events. And here, while Professor Heather was speaking, I read that and I marked it with red in my slide because it has a relation with what she was saying. So for instance, in our concept here, 58% of perpetrators had problem with abuse of alcohol, almost 6% of the cases. 61% of the cases had a recent breakup, or at least an attempt to break up the relationship. 88% of the cases had the history of excessive jealousy or stalking and control of these women. So it gives us an overview of what are the contexts that often this violence take place against women. And to finish this research here, we will analyze the prior processes of this 1/4 of cases with prior registers and what we were able to see that in this case, all of them, we could say that the judges didn't do what their best to avoid their deaths. In my 20 minutes here, I'm going to head to my conclusion against women. So to finish, I believe that these researchers that I mentioned, it raises two important things. So the first, the importance to have public policies, institutionalization based on evidence. And the second, the institutionalization of statistics and qualified data that enable us to have public policies based on these data. We are on baby steps in Brazil in producing high quality data to reach all the fidelity of unity, just not a locality or a single place. So these both researchers approached all the country, and they are showing us the potential to have an impact in our organization. So once more, thank you everyone, and I am here for the debates. Thank you.
Okay, now I'm in the right channel. Thank you, Thiago, very much for your presentation, for your concern for the time, even though I think we're also captured by your presentation. We were not concerned for the time. I will open now for the panelists to ask questions to each other, and then we will open to the floor. And the first question from the floor will come from Benedita Nascimento. But before we get there, I want to ask the panelists to ask each other. And I will not ask this, but I do wonder about the psychology graduates or psychologists' ability to actually deeply analyze and actually have enough ability to deeply analyze what is coercive control and even psychological violence and really contribute to that process. I think we still have some disjointed communication there in Australia and most likely in Brazil. But I do wonder, I don't know if Thiago and Heather want to bring that to some form of answer about how to regulate violence in law. Many times what you're regulating is relationships. So many times you're not questioning, so especially in Australia with the non-fatal strangulation law, in Queensland, it's very heavy handed on, is it a real relationship? Were them still in a relationship? Was that a real relationship? And in immigration, we experience that a lot. And I wonder how much you see the law around violence, instead of regulating violence and punishing violence, actually regulating relationships and wondering too much about if it's a relationship. But please feel free to answer or not and ask questions to each other. But would you like to start, Thiago, as you're the last one?
Yes. Regarding your question specifically, I believe this is a challenge. If from one side, we can use law as a changing driver of social relationships, on the other hand, at any time where I'm studying the law with certain concept that is much wider from the social science, I have the risk of reducing the meaning of that specific concept. And sometimes this is ending being a trap. And when I will provide this concept to be operated by institutions that by definition, they are traditional institutions. That's the case of the police force or the justice system. I hope I have approached this topic. From my questions, actually, as we have the time concern, I will take the opportunity to ask some questions that we have on chat box. So Miranda Calazans has a question for Professor Heather. That is the following. From the Australian monitoring experience, there are some studies of violence against women with use of fire in the residence, and she's going to indicate that we have recently events of the perpetrator to burning the woman during an aggression. So it's the physical aggression using fire. And Marcos, I have another question for Marcos. I just missed this one. So let's have this one. But before Professor Heather answer this question, I see here that we have here Benedita Nascimento, that is one of the social movement Levante Feminista representative, and she asked to introduce the movement and ask some questions for us. So maybe if Anna allow me, if we can give the floor to Benedita first. Benedita. Hi, good evening, good afternoon, everyone. Can you hear me well? Okay. Well, I am Benedita Nascimento, woman from Amazonia, from Porto Velho, Rondônia, a member of the Levante Feminista. It is a feminist network. It is the Women Popular Forum, and we have a network of women from Amazonia that it is also part of the Levante movement here in Brazil. In Brazil, the single national movement for women here, and on behalf of all these women, I would like to greet everyone. Well, I know that we are concerned about the time, but I will try to be very briefly and objective. First, I'd like to congratulate this initiative. I think that it's very important considering that it's 21st century, but it's important to have these topics being discussed by the academia, the universities, to make science, but in science that can in fact bring the reality to the university, to the academia, and also to take the academia out of their philosophical university to go to a reality that is very important, that is the living, that is of this reality. And I think that it's a very important advance because this struggle is from the feminists for a long time ago. So it is very important to have this connection with Brazil and Australia, and especially in this perspective of initiative that gathers the academia to discuss this problem. And another thing that is very important, it is to reaffirm that the Brazilian legislation, they are strong and necessary in our context, in our reality of violence against women and girls and femicide. However, we know that the past years we have been suffering with the public policies deconstruction. And I want to say that with Professor Marcos, that is very important, the work that you are developing. Facing in his state, in Victoria, in this perspective of protocol to bring the unified health system and within this, the health system to work in a perspective with tools that enables this view to create strategies with more resources. But we know that considering the legislation and some isolated services in the health system, we have said that for a long time, since the creation of the SUS and the SUS, these networks, the health and social systems, that they need to work together. We cannot handle some events and phenomena such as the violence with no integrated services and also continuous services. Here in Brazil, unfortunately, we have this practice that we create a service, and when we change our administration, everything is destroyed. So we need to have these systems so to be, in fact, not only as public policies and effective public policies, but actually to be developed continuously from government to government, and the networks need to support that. So I have a legislation against femicide, a law to be to tackle the femicide, but if I don't have structured services and continuous services, I will not be capable to fight this reality. So we have this problem. And even more now with this government, with the current Brazilian administration, the destruction of the public policies, if we have the problem to not work with public policies in health, education, public security, we know that we cannot handle violence only with public security.
And if we don't bring that as a practice of intervention to face these violences, we won't be able to get away from that. So this feminist levante, well, it comes from that. It comes from for it's not only to be in the agenda and the increase of the femicides in Brazil and the different territories, but also to raise awareness to society and build paths to work with resources that may tackle this violence within the public policies. But how are we going to do so if it's all being disassembled and all being ended? If you come to the Amazon, this is the scenario. You see all public policies just disappearing, going down. And we may say that, oh, we were able to bring the Mariada Penal, but women keep dying. Right now, I just got back because a professor, a female professor, was murdered, professor of philosophy. She was murdered by her spouse because she didn't want to be in the relationship anymore. So this this feminist levant is it's not only to raise awareness in society, but also to build a path that we could generate resources and potentialize our interventions to try and prevent this reality. But unfortunately, the Brazilian administration doesn't hear us, and they don't want to hear us. They turn their back to society. They turn their back to women. Women are dying every day here, unfortunately, in our country and in the communities that we have in all areas. So it's cruel murders, and different realities that we have ahead of us in the scenario of femicide, in the homicides, murdering our women and our girls. And if we can't prevent the childhood pregnancy, because they will end up dying as well, because we're living a cycle of poverty. But to work violent, it's not only a matter of security or organic of law. We need to have other public policies, and that's why it's so important to have this flow. And I'm going to go to my question. So in this flow of services, how can we have a flow of services to to shelter this woman who is a victim of violence and now suffer with serious issues, which is this flow? We re-victimize them, but we're not able in Brazil to identify a necessary flow, a systemic flow that can put this woman in this network, and this network would potentialize that woman not to reach a femicide, and we are not being able to pull that off. And my question is this: you in Australia, is there any magic bullet? Are there studies? Is there science or experiences that tell us that we should be working with this flow, within this perspective of potentialization of services, to remove this woman of this route towards femicide? So what is the flow? And that's the question I wanted to bring you. I apologize for arriving so late, but thank you very much for the invitation. It's an honor to be here with you. I wish I were better prepared, but I was not able to follow the discussion. But I'm very happy to be here, and I hope I'm invited more times to contribute to this process of discussion. Thank you.
Thank you, Benedita. Marcos, you raise your hand. Do you want to start there?
Well, I felt provoked by her words, and I'd like to say good evening and to thank her for being here, because we can't build policies and discuss interventions without having the social movements with us, without having the ones who are leading and participating with people, with the survivors, with the women. So I'd like to thank you for what you have brought. I believe it's great provocation, and certainly we're leaving this assembling of all policies with the very few advances that we've had in terms of policies and law and scenarios and strategies. We are in a scenario of going back, regression. We hope this can be over soon, and we go back to walking forward. In the unified health system, we see that a lot. I have brought very briefly talking about the primary care, but the primary care, which is the entrance door in the people in healthcare, it's suffering more and more cuts of resources, of personnel, of human resources, of material resources as well. So it is a scenario that is very concerning. And when you ask Australia, I'd say that here in Brazil, the experience that I bring of having research together with the House of Brazilian Women, I'm not saying it's a miracle or it's not the silver bullet, but it advances in the sense of having all public services in a single place. So the woman would go to a healthcare service, and there she would be referred to the police station, and then they'd have to go to be examined, and then she would need to find a shelter to be away from home. And if you think about women that are more vulnerable economically, they wouldn't have even money for the bus fare, because if you don't work, you don't earn that day. So to have all these services in a single place that close to a bus stop, which is the case of Curitiba, perhaps this facilitates. I'm not saying this is a miracle. It's not magic, but it is a first step. But let's hear our international colleagues. They have experience on that. And I'll add one question, which is a curiosity that I've had with Professor Heather on the death reviews. I was curious to know if there were any cases of same sex couples. And the other question is about the intervention with the authors, with the perpetrators. If there are any results or any assessment with this type of strategy, because here in Brazil, it's still very incipient. So what could we learn from Australia on that? That's what I wanted to bring, okay? Thank you very much once again.
So thank you for that, and thanks for the comments from Benedita as well. And there's a lot to respond to, but I think that in terms of the services, I think you're right, Marcus. The example you gave is a really good way of bringing services together. I think the two of the things that I would point to that we've tried to make that service trajectory work for women is the joined up risk assessments. So having the same forms of risk assessments across systems, and also the information sharing across systems. Imperfect, but steps towards making those kinds of connections. There's also movements towards co-location of services in Australia as well, and there are some experiments with co-locating women's services and housing services with police stations and so on, and early days, but there's questions around that as well. So there are some things happening, but not quick enough ever, and so on. I mean, I would say in terms of prevention, and none of us have talked about this, but really there's a work of prevention much earlier on, and organisations like Our Watch in Australia are really working to change cultural attitudes around relationships and gender structures and so on. And so that's really work with schools and students and kids, trying to change the way they think about each other and in their relationships. So I think that's incredibly important too, but obviously that doesn't help the women now who are experiencing violence in their relationships. In terms of the LGBTI communities, there's less research amongst these communities, but yes, there are some examples of death reviews and involving same-sex couples, for example. I can't really comment right now on what those have found. I haven't really looked closely at those, but there are examples within the reviews. So if we can follow up on that later if you like. In terms of perpetrator interventions, one thing that stood out to me, I was actually an expert in the Hannah Clark murder in Queensland, which was a murder where she was killed by her husband and her 3 children were killed, and then he killed himself. He basically set the car on fire and they were all killed in fire. And interestingly, the perpetrator in that case, Rowan Baxter, had sought psychological services and had actually been to a psychologist on 4 or 5 occasions. And the psychologist in that case had not had any domestic violence training, did not see her client through a domestic violence lens. And so there were really interesting suggestions and recommendations made by the coroner. Actually, I don't think they've come out yet, but they will be made around training for psychologists in relation to seeing the red flags and patterns, and maybe also thinking about how they might be brought into the information sharing, because in Hannah Clark's case, there was already a lot of services around her and they were sharing information, but a key service was not in that mix. So there are some kinds of ways forward on that. The resources problem is constant for us in Australia as well. So in that particular case involving Hannah Clark, the perpetrator had also reached out to Men's Behaviour Services saying, I'm wanting to deal with my controlling behaviour. You know, she might come back if I deal with my controlling behaviour. And that call was made a couple of days before he killed, and they hadn't got back to him to make an appointment. So, you know, the resources question is always an issue here. And I think that there's a lot of things that could work better if they were better resourced. And so that's just a constant, I think. The other point that was raised at some point about fire as well, and that connects to this Hannah Clark case. When the Hannah Clark case came and I started working on that, I did get interested in this question of fire, because I think we don't talk about it yet. And yet it's in the background of so many of these domestic and family violence cases. So I did a research paper, which is currently under review, of all of the cases involving fire that I could find. And they seem to settle in two distinct groups. One which was using fire to control, so threats of setting people on fire, burning property of the woman that she cared about, so while they were in the relationship, as a method of control. Sometimes those lost control and they had much more damaging effects than I think were planned, but it was a method of control. And then in cases of separation, as Dobash would talk about, the English researchers, that while they're together, the aspiration is control, but when they separate, his aspiration might turn to destruction, and they've suggested. And so where the separation is settled and she's not coming back, he might decide, well, I'll destroy her, maybe myself as well, but definitely her. And I saw a lot of cases where fire was used to destroy her and her house, and sometimes the children as well. So, or sometimes to destroy the children in order to effectively destroy her. So I think fire is something we should be talking a lot more about. I know in Northern America, there is work being done with fire services and police to assist with to try to make homes safe, because a lot of these cases of murder by fire or manslaughter by fire, as sometimes they're found to be, it's situations where the house is burnt down with her in it in the middle of the night or at a time where she, you know, is asleep. And so making the house fire safe and working with women who've been separated with fire service to look at ways to ensure safety in her house. So there is work being done in this space, but it's very early days, I think. But I think a really important issue, and it isn't in our risk assessment tools, and I'm not sure we've thought about how it might be included or how we might use it. So because it's something that often there isn't an history of setting fires or using fires amongst these men, but is it that makes them use fire in these cases? So I think that was a really interesting point that was raised as well. So yeah, thank you. And thank you everyone for sharing all the information and experiences. I think it's been really interesting for me. I've written so many notes as well this morning.
Thank you, Heather. I'm going to follow now in Portuguese because we have questions in Portuguese. Is it good to read these questions? We have 4 questions here and 2 for Thiago. Maybe I can read and then you can prepare your answer for this question. There's another question for Heather. How does Australia handle domestic violence that are not perpetrated by intimate partners? For instance, domestic violence such as parents against children or between siblings. And there's another question for Marcus, that inclusion of women in the statistics for violence against women. If we have this demand of gypsy women. And another question for Thiago, in our research by the MPU was determined how long the judiciary takes to approve or not the request, and among the requests from the victim in the police station, and then the judiciary analysis, how long did it take, the analysis? Another question for Thiago as well. Most of domestic violence against women, there is a dependence, financial dependence by women. And most of these women didn't have the possibility of professional qualification. As a public policy, would it be nice to send them to professional education in case of they want to achieve their financial independence? Would it be any strategy? And is it be possible in the justice system partnerships to referral for any partner institutions? I don't know if you can start with Heather. And these are the questions.
Okay, the family violence question. So family violence is a broad concept in Australia and all our jurisdictions. It includes intimate partner violence, but also violence between other family members. The exceptions to that, I think, are around children, parents to children. I think that would be described as child abuse, and there's separate legislation around child abuse. There are questions, though, there's a lot of research happening, and I've been doing some with Kate Fitzgibbon, who's not here today, around adolescent family violence. So things around sibling abuse and children to parents. So children under 18 to their parents, for example. So often we find when there's been a domestic and family violence relationship between intimate partners and the children are growing up in that, and the male partner leaves, maybe the 16-year-old son takes over that role of being quite abusive to his mother. And so that is treated slightly differently in Australia as well, in recognition that these people are children still, and there's a real reluctance often of parents to get those children involved in criminal justice systems. So there have been some intervention programs set up by some people around Australia, specifically targeted at interventions which are to adolescent family violence, which are mostly around more family-oriented therapy. So the mother and the son would go to therapy together and try to work out the relationship, because often women do not want to separate from their child. They want to try to make sure that they can return to a relationship which is functional. And the same story with siblings. These are dependent children often on their parent. And so it's a very different situation between that and intimate partner violence. So we do treat that differently. But, you know, in recognition of there is potential to recognise broader family context. So, you know, the mother-in-law being violent who's living in the house with her son and his wife, and she's being violent to the wife, potentially that could be recognised in family violence context in Australia. You know, the focus though in our courts, I would say, is very much though on, you know, intimate partner violence. That would be the majority of cases that we're looking at.
Thank you, Heather. Marcus? Thank you. I will try to answer Sonia's question, that is from Gypsies groups. There's a question about the inclusion of these data on Gypsy women. So I'm going to speak now as a researcher, okay, Sonia. In Brazil, we need to encourage the research with the minority groups, with ethnical groups, with minorities that suffer inequalities. So I would say, do we need to share the research with these peoples? We almost have no data, national data on this group, the poor Roman population. We have no consistent data on indigenous population, our originary peoples, with peoples from the forests and field that have been that represent the Amazon region. So I have people living in these places that are geographically isolated from the center. And when we think on instruments, tools, such as hospitals, police stations, Casa da Mulher Brasileira, Brazilian Women's House, to assist these people. See, there is a long way through rivers to reach these places, these institutions. So for me, as a professional work, I was always thinking on persons with disabilities. And one specific event, there was a woman that we have in primary care services, and she was a person with disability. She was paraplegic, and she said it was an accident. And later we found out that her husband beaten her with a chair, and then she was paraplegic. This is a similar case of Mariada Penal, that is the woman that gives the name to the law. She was paraplegic because of the husband. So of these groups, vulnerable groups, such as the migrant people, either internal migrants and migrants from other countries, we need to have researchers with these groups. This is a need, a necessity, and we get back to the same thing. A government that doesn't value or promote research, it is hard to plan public policies, to plan interventions. But I totally agree with you. We need more research to know the reality of each specific group. This is my contribution. Thank you very much. Thank you, Marcos. Thiago, do you want to close the final remarks? Very briefly, because I see that we are 4 minutes over our time. So just to close, 2 questions. What is the deadline since the protective measure request and the decision of the judge? According to our research, it is fast. Sometimes the same day, maximum the next day. The problem is not between the request and the decision. It is in the judge, in fact, to approve, to accept the protective measure, and we have difference between the courts. And a second problem that is, once the judge approves the measure, to effectively have the perpetrator aware about it. Because sometimes when the perpetrator leaves the house, there is a problem to localize them. It is a problem to the judge staff to subpoena the perpetrator. And according to our research on femicides that we have, of all femicides that we have, only 3 cases the woman was killed during the emergent protective measure. In these 3 cases, the perpetrator wasn't subpoenaed. There was a protective measure. So exactly in this situation, trying to subpoena the perpetrator, trying to locate them, and then he goes and kills the women. So the problem between the time to subpoena them. And under the financial dependence, according to our research, the data is quite different. Not on the general violence victims, so the victims that were killed. According to our research, only 15% of women have no income. Only 15% of the women killed has no income, and they were 100% dependent on the perpetrator. 66% of the women, they have 1 minimum wage, 20% 1 to 2 minimum wages, and there's smaller percentages in other levels. So most of them had a professions, but what were those professions? They were highly poor professions. They are work with the bus, transportation, recycling services, domestic service. And when we compared with the perpetrator income, the perpetrator make much more than them. So they contribute significantly in the family's income. So despite this correction, yes, promoting the independence of the women in the labor market is very important to provide the women the condition to leave the violent situation. And of course, all the programs to integrate the intervention with the autonomy and promotion in the work, they are all very welcome. And also, in the case da mulher, Brazilian women have one of the sectors of the institutions usually is a sector that promotes the integration with the income and job department, with the social assistance, the social benefits, providing the condition to women to make the living and also to have the condition to leave the violent relationship. Thank you very much. Thank you all the speakers. I think that this conversation, they need to continue. We need more time to discuss because this is inspiring for everyone as it was for me. And thank you very much for the participants, and the speakers once more. Thank you, everyone, for your participation, especially Professor Heather and Anna, that they are out in Australia and they wake up very early to be with us here today in this discussion. Thank you very much. And we have 2 further discussions, right? Yes, this is our second webinar in a series of 4. So we have 3 more. So we will continue with our further webinars very soon. May 26th is the next one. So Thank you, everyone. And so our works are finished. Thank you very much. C, who kills a woman kills humanity. Thank you very much.